Welcome to the Arbitration Conversation. So in this arbitration conversation, we're going to talk to another expert in the field of arbitration, both from a professor standpoint and a practitioner standpoint. He is a professor at the University of Iowa teaching arbitration, but at the same time, he's a very avid arbitrator and has been involved in arbitrations for a very long time and is in Iowa. So Michael Pitton is his name, and he is a huge expert. I'm excited to hear from him and to hear his thoughts. He's been an attorney for a long time. He has his own law firm. And as I said, he teaches arbitration law. So first of all, Michael, thank you for taking time because I know you're very, very busy.
Well, thank you very much for inviting me, Amy. I'm excited to get together with you on this, and looking forward. We're going to do the symposium coming up as well.
Yes, thank you. I was going to mention that. Looking forward to it, talking about arbitration in the age of COVID and how it's changed, which actually is a perfect transition to a question I wanted to ask you that no one's really talked about. So the arbitration conversation was kind of a project that started out as almost like a time capsule because it was right after COVID hit. And, some people were baking bread. And I said, you know what, instead of baking bread, I'm going to interview people about arbitration. And a lot of people have talked about arbitrations moving online, but how did arbitrations, or was it even possible to do arbitrations in person, but following CDC guidelines?
Yeah, and that's an interesting situation too, Amy. It's one that I hadn't expected. I accepted an appointment to do an arbitration recently in Rock Island, Illinois. And the very first thing I thought was that we'd be looking at an online Zoom type arbitration. But instead, the parties, the attorneys, were very clear that they wanted it in person and live. And so the first thought was, well, I'm not sure about that. And do we really want to do that? And then once they indicated that, yes, this was their requirement for this, I thought, well, if that's going to happen, how are we going to do this and do it safely for everyone? So the first thought was location. What kind of a location are we going to find? And there, Rock Island, fortunately, has an arbitration center with a large courtroom type setting, more in terms of size than in terms of layout, but where it's very easy to distance from the parties and to give the witnesses and the parties quite a bit of latitude and space. So that was encouraging. And then we checked into the sanitization methods and the cleanliness aspect. We talked about masks. So this is all now becoming part of what would normally be a pre-hearing conference, is how we handle the COVID issues. And so then I went back to the Supreme Court guidelines for Iowa and Illinois and how they were handling in-person hearings. So we came up with a protocol on use of masks and when someone could take them off, how close they would be to others. It would be primarily just when they're speaking. And then how we would handle traffic flow in and out of the room, of the arbitration room. And we got there, it turned out that they were still having a hearing previously. So we were delayed in our commencement, our beginning of the arbitration, to allow for some of these considerations, make sure everybody left appropriately and safely. And then when we got in, we came in a staggered way, left in a staggered way as well with distance. And it worked out pretty well. Everybody felt very safe. They felt that they were heard because they could be seen. When the attorneys spoke, the attorneys could take off their masks. When the witnesses testified, they could take off their masks. Otherwise, everyone was masked up and kept a distance. So with some hesitation, I agreed to do it ahead of time, but with the protocol and safety measures, it seemed to work out fine.
And I'd imagine, yeah. Oh, like you said, being heard, in some situations, I suppose you really do want to have that sort of in-person aspect.
Oh, absolutely. And as you know, the document exchange is much more cumbersome on Zoom. We're not all very, technically savvy on screen sharing issues, and then people's faces disappear. So it provided for great ease in terms of communication, visibility of the witnesses, and also the exchange of documents, among other things.
Do you think with all the sort of protocols, and I'm just thinking through as you were talking about it, did it add a lot of time to the process in your view? Because obviously it's going to take more time. You're going to have to clean things in between witnesses. You're going to have, like you said, the staggered process leaving the room and things along those lines. Did it add much to the time that the process to take place?
Well, I would say, and in this particular instance, it did add additional time to what we normally would expect in an arbitration hearing, one in person and live. But when you compare it to a Zoom arbitration hearing, there it would be quicker to hear testimony, but from my experience, it's slower to go through documents by Zoom. So I think the time that we lost in the in-person setup and method, we gained in the time that would otherwise be spent with Zoom document exchange, for example.
Right. No, but those are all really good points because there's some parties that are just waiting it out because they don't want to do a Zoom arbitration, and so they're just waiting until they feel safe to do an in-person arbitration. But as you're stating, I mean, there are ways that you can do it safely, and thinking about those and putting it in, I would think a big takeaway for anyone listening is to make sure that you include the protocol or include the plans in any kind of a preliminary hearing or preliminary order.
Yes, and also to make it consistent, as you say, with CDC guidelines, and then also with the Supreme Court protocol of the particular jurisdiction as well.
So, and I know this is kind of a jump to a different issue, but it's another one that we really haven't had an opportunity to explore very far, but I know you have expertise. And I guess I wanted to get your thoughts, if you could explain sort of arbitration in a university setting and how that might apply.
Sure. Well, the experiences I've had relate to a couple of primary procedures. I know you've had Justice Turnus on recently, and she talked about the use of arbitration methodology in student adjudications for harassment and such. What I've seen for that has been in a couple of settings. One related to faculty disputes, oftentimes interfaculty conflicts, which may involve rule violations, bullying, harassment, issues of the sort that relate to faculty interaction. And in that type of instance, it's primarily an investigation and then also recommended recommendations following the investigation as to whether there'd been a violation of the code of conduct, and if so, which faculty member may have violated the code of conduct.
So, and I'm curious because I know, well, I'm chair of the campus mediation services committee, and we generally use mediation. So I wondered if it's a stepped process. So do a lot of these conflicts generally go first to mediation and then to an evaluator, or how does that work?
Well, the ones that I've seen are based on grievance procedures in the faculty handbook or the particular policies where mediation may not be required as a prerequisite. And instead, there's a written complaint that's filed with the university, and then the university has an obligation to investigate. And of course, in many cases, in order to protect themselves and provide the fairest type of alternative, they look for third parties to do those investigations and make recommendations as well. So the ones I've had have not had, they've had some informal discussions with the dean perhaps, but if those don't work, and that's typically the case when they get to that level, then it moves towards more of an arbitral investigation setting, probably more comparable to a non-binding arbitration with recommendations, and then the administration follows through in the manner they see fit.
That makes sense. I mean, I can definitely see that, especially when you have a third party who's not part, necessarily not an insider, who can be a third party neutral to provide an evaluation of those kinds of cases. And it kind of leads me to another question, because, when you talk about all these different areas of arbitration, there's so many different types and kinds and areas. And I know my students, I'm sure your students as well, are always wondering, how do I get into it, right? Like, is it even possible for someone after they graduate from law school? How do they have to wait till they've been a retired judge or they've been a lawyer for a billion years? How do they even get into those types of jobs? I wondered if you had any thoughts on, I guess, number one, getting the training necessary, and then number two, really tips and advice for those that are thinking, gosh, I'd really love to get into this. I just really don't know how.
Sure, and that does seem to be a common area of interest with students. Once they finish your class or mine, they come out thinking, well, how can I be an arbitrator? How do I get into this? And one of the things I tell them early on, and as you know, I do trial work as well, but I tell them early on that you're going to be involved in many more arbitration hearings than you ever will be in jury trials through your career. And so, yeah, I've yet to be proven wrong on that, especially with the statistics that we're seeing. But then they're interested in the process and how do they get into ADR as an arbitrator or perhaps a mediator. And there, one of the things that I talk to them about is having the substantive knowledge in a particular area that would be of interest to people who need to have decisions made and want somebody with the expertise that comes along with the obligation to provide a thorough review of the evidence and a decision. And so I encourage them to look at what substantive area of law will they find that they can develop some expertise in, so they have some credibility in making decisions. The next aspect, the second aspect, would be training, of course, and what kind of training may be available to students or to attorneys, for that matter, in acquiring the skills necessary to conduct arbitrations. And not sure how it is in Missouri. In Iowa, that training is quite limited. Some of the bigger cities, AAA, of course, will have training sessions for commercial and other types of arbitrations. I was asked to put together two arbitration training sessions. One, a basic arbitration session for 6 hours over one day, and then an advanced training program as well on the second day. This was primarily for Minneapolis, Minnesota criteria to be part of the neutrals roster in Minnesota. There they have a rule that in order to schedule cases for trial, you have to go through ADR. And so one of the methods of ADR is non-binding arbitration. Under their particular rule 114, there has to be certified training to provide for a background sufficient to participate as a neutral as part of that process. And so I was asked to put together a program by the Mediation Center up in Minneapolis, and we did that, and had a one-day session, and then it seemed to be of interest to expand that into a second day for advanced training as well. So getting the training it would be another aspect of that, and then it's doing as many arbitrations as you can, or mediations for that matter, as well. So those would be the beginning steps I would see.
Yeah, no, I mean, that's a really good point. By the way, I practiced law in Minneapolis and did a ton of arbitrations in that area in Minneapolis, construction arbitration. So as you were talking about that, it kind of brought back memories and to those important rules under Minnesota law. But I think it raises the issue that's important for anyone to think about, which is, in the state in which they're practicing, look at what's available, because I think there's different types and kinds of arbitration. and rosters to get on, depending on where you're located. I also think that holds true with sort of the different organizations. What do you see, for example, in the Iowa region, which, because it seems like in different places, there's different arbitration organizations that hold a lot of weight when it comes to being selected as an arbitrator?
Yeah, and one of the things, and that's, you're very correct. It's in terms of, for example, in Minneapolis, when you were there and when I was there, AAA looms very large up there. There's lots of arbitrations. Attorneys aren't afraid of those. And then when I transferred my practice primarily to Iowa, what I found was the legal community here has not quite adopted arbitration fully as fully as it can to resolve some of the issues that we're facing, like court delays, and especially with COVID and such. So arbitration has been much more of a limited format in Iowa. There's not that many people who are doing it. There are some who are on AAA panels, but oftentimes the parties look to ad hoc appointments rather than AAA for various reasons. And so there is, I think, still a limited use of arbitrations, although it's growing. And I think should be growing even more with what we're seeing with court delays as bad as they are.
Yeah, that was actually a perfect segue, because that was going to be my next question as I'm thinking through, court delays are going to be crazy, and as people wait in line to get a trial date, are they jumping ship and deciding to go to arbitration? I don't know what you've been seeing in your practice.
I would say they should be. They should be jumping ship. I had a case, a trial setting conference today for a case that we filed in 2017 that's been continued twice. And when we got to the court administrator for now this third continuance due to COVID, well, this most recent one due to COVID, the court administrator started talking late 2022 into 2023. Now this is a $1 million claim in a case that was filed in 2017, which may very well go on appeal after the trial is done. And so how many years, nearly a decade, are we talking about there? Yeah. So that's scary stuff, that it's going that long. Witnesses, experts, where are they going to all be at? Changes in municipal administration, all kinds of things. So I think they should be looking at arbitration much more heavily, certainly mediation, if nothing else. But when we're talking 5, 6, 7 years, and on top of that, Amy, here we've been nearly a year with COVID. So we've got a year of jury trials pushed out. Mm-hmm. And under the current Supreme Court orders in Iowa, they have a prioritization schedule of what cases are going to get tried as they resume. And when you look at the prioritization schedule, of course, criminal cases are up on the top, as well as some others. Civil cases involving monetary damages are 22nd on the list of priorities, just ahead of small claims court cases. Wow. So once it begins and the floodgates open, I don't know where it's going to go.
No, that's and that's a good note to end on, go to arbitration, right? And I do think, though, that's a really good point. There's so many really good arbitrators out there not getting selected. And I think that it just makes sense in a lot of these situations. And there's ways to sort of craft the process to make sense for you, depending on the type of problem, which absolutely is available through arbitration. So listen, Michael, thank you for taking time, and thank you very much for your advice, your thoughts, your tips, really helpful stuff. So thank you.
You are very welcome, Amy. Thank you for inviting me. It's good to see you again.
Absolutely.